Hello, welcome everyone to today's program. From policy to planning, strategic, tax, and estate planning insights, featuring a couple of our wealth strategists on our team. As we emerge from the election season, many are considering how potential tax policy could affect their wealth strategies. Post-election periods often bring shifts in the tax and estate planning landscape, making it an ideal time to review strategies that safeguard your financial plan and to capitalize on new opportunities as policies evolve. With year-end planning already underway, now is a critical moment to assess any adjustments needed before the close of the year. I'm John Crow, Regional Managing Director and President of the Cresset Trust Company. Cresset was founded with a vision to reinvent the way people experience wealth by providing access to talent, ideas, and investment opportunities available to the largest single-family offices and endowments. Our extensive ecosystem provides opportunities to connect directly with a variety of industry leaders. And today, I'm super excited to welcome our very own Richard Lowry and Michelle Chapin, both managing directors on our wealth strategy team. And I want to thank them both for joining us today. Today, we're going to dive into potential tax and estate planning implications of post-election policy shifts and how high net worth individuals can adapt their strategies to navigate these changes effectively. With that, I would like to welcome Richard Lowry and Michelle Chapin.
Thanks, John. So the past really 6 months, and especially the past week, 2 weeks, has really seen a pretty significant shift in the tax policy landscape. Throughout the last year, most of you have seen in the media, really two different parties and two different platforms as it related to tax policy. And what that meant for each of your personal plans has really been dependent on which party ultimately prevailed and in what ways they prevailed. So now that we have final election results in and the dust has started to settle, we can start assessing from a real world perspective what the impacts of the election will be on each of your individual plans and how it may shape the conversations that we'll be having over not just the next year or so, but the next 2 to 4 years as well. So just as a quick recap, though I'm sure most of you didn't miss the news, we had some pretty significant changes at the top of government. The first is that we will have a new presidential administration starting in the new year. The Trump administration will have its second term, a 4-year term. We've also had a major change on Capitol Hill. While the U.S. House of Representatives was previously controlled by the Republican Party, there has been a swing in the Senate, meaning that there is now unified control of Capitol Hill. Both the Senate and the House will ultimately be Republican-led, at least for the next 2 years. What that means from a practical standpoint, when you take both of those together, is that we've also had an indirect change to the judiciary. The ability to appoint judges, both at the federal appeals and district court level, as well as at the Supreme Court level, are all impacted by the election changes we've seen. And that also extends to some courts you may be less familiar with as well, such as the U.S. Tax Court. So while some of those seats sit vacant and will ultimately be filled, it is important to remember that tax law is just that, it's law. And how the courts interpret it and how they apply it will be meaningful, not just in the next couple of years, but in decades to come. So while we may see some new tax legislation, some tax policies that pop up in the coming weeks, in the coming months, certainly over the next couple of years, there may be some long-term systematic changes that fundamentally alter how we look at tax policy on a go-forward basis. So with that in mind, what can we ultimately expect now that we know who's going to control the reins in Washington for the next 2 years? First, we can talk about really what did the Trump campaign promise and how realistic is it that any of those promises, or at least some of the big ones, will ultimately come to fruition. An impact or a change to the presidency doesn't just include tax law and tax policies, it's also the executive branch. And a part of the executive branch is the US Treasury and the IRS. Changes in presidential leadership have a direct impact on the IRS, and changes on Capitol Hill do as well. So what do the election results ultimately mean for what we'll see coming out of the halls of the IRS? And what will it, practically speaking, mean for each of you as you navigate decisions around tax positions to take, strategies to pursue, and ultimately your planning for the next couple of years? As I touched on briefly, courts are going to change. Certainly, we may see some changes at some of the most high-profile institutions like the Supreme Court, but we'll see changes as well, really throughout the system. And what does that mean for the decisions you make and the risks that you take on as you think about what strategies ultimately make the most sense for you and your family? And then the last and probably biggest topic of today, and one that you're going to hear a lot about over the next, call it 8 to 12 months, is the Tax Cut and Jobs Act. While there was always a knowledge that ultimately that act was set to sunset or expire at the end of 2025, the probability of it being extended has changed. While we don't know exactly what the provisions will look like, we can talk through what some of the implications are for how you should be approaching not just your estate tax planning, your estate planning more broadly, but also some of the income tax decisions that may pop up for you throughout the next year. So starting with the Trump campaign, really what we ran into as we got into the end of the year, or certainly the end of the election cycle, was a giveaway contest. There was a lot of policy proposals that, while they made for great campaign literature, likely aren't going to actually see the light of day when it comes to creating tax policy on Capitol Hill and seeing new bills and legislation that will impact your planning. So one of the first things we heard a lot about really was tariffs. This was a staple of the Trump administration in their first term. It was used as a revenue raiser as well as a bit of an economic cudgel to advance different foreign policy objectives. So an in-depth discussion of really what tariff policy looks like goes beyond the scope of today's discussion. Our very own Jack Ablin and our national investment team are closely monitoring the progression of any tariff proposals out of the new administration, and we'll be putting out pieces as well as their monthly market updates to discuss in more depth how those tariff policies will not only impact you individually, but more importantly, will impact the businesses that comprise your stock portfolios. So at a really high level, what the Trump administration has proposed is a 20% increase across the board on domestic imports, as well as a more targeted 60% increase in what are called Section 301 tariffs on China. So the objective of that is both to protect onshore manufacturing and onshore good production, but it's also meant to act as a revenue raiser to help offset some of the tax policies we're going to talk about more today. So while the two are related, they are distinct in terms of their objectives, but it is important to note that the ability for Congress and the Trump administration to put forward a lot of their tax policies and a lot of their initiatives do cost money and will ultimately be tied back to revenue raisers like tariffs. From a tax standpoint, a tariff is an indirect tax. The most recent computation that I've seen puts the average cost to the American consumer at about $1,700 in additional costs per year. So you can think of that as an indirect tax. So while we may see reductions in tax rates, we do also have to offset that against any incremental increases in the cost of just living in the US. One of the others, and I mentioned this at the start, themes that really popped up with the administration as they both ran towards Election Day was the idea of giveaways. So for the Trump administration, the way that came out was in the form of proposals for no income tax on tips. So, for restaurant workers and more of the working American populace who rely on tips, that was meant to be a great incentive. No tax on Social Security distributions. That tends to hit the higher end of the income spectrum for individuals who would be subject to income tax on any Social Security payouts and retirement payouts. And no tax on overtime. So for shift workers or individuals who were subject to that, removing the tax burden that comes with those additional hours. From a practical standpoint, while all of those made for great TV and great electioneering, From a practical standpoint, they're pretty unlikely to actually make it through. The reason for that is going to become clear as we talk about some of the other extensions and heavier hitting tax policy that is currently on the Republican agenda. As tax policy gets put forward, it has to be paid for in some regard. And while there was always a growing appetite among the American populace for deficit spending, there are generally limits to that. And from most economists' view, the idea of having a pretty sizable chunk of the tax base be excluded from tax at the same time that we're already floating additional tax cuts will make it unpalatable both politically and from a revenue standpoint for those initiatives to pass. So while we can't ever rule anything out, those are likely to fall more in the bucket of 2024 election cycle promises rather than implementable tax policy. The same would be true for an itemized deduction for auto loan interest. This was never really fleshed out, so there's not any indication of where the cap would have been. If we see something along those lines, it would likely be capped. Don't expect to get an interest deduction on, a six-figure car. And then the last was the elimination of green energy subsidies. For some of you who may be located in states that already have pretty robust green infrastructures, this could be meaningful in terms of car credits, in terms of subsidization for solar energy or some of the other initiatives. And that's certainly something we should expect to see fleshed out more in the coming months. So moving on from kind of what was talked about on the campaign trail, what are the immediate things we're likely to see starting in January? Most of those center really around Congress and the IRS because they're not beholden to having to put out legislation in order to make meaningful changes. So a topic of conversation that has popped up ever since it was initially enacted is the clawback of some of the additional IRS funding that was passed through some Democratic legislation a few years ago. The meaningful impact of that for everybody on this call is that it will result in a reduced IRS headcount. So for some, that may be worthy of a cheer, for others not. But what it does mean, practically speaking, is there'll be a reduction in the number of IRS enforcement agents, so the individuals that would do audits, as well as customer service and IT agents, so the people that help with calls if you have a question, or help make sure that the e-filing system that we all rely upon takes place. About half of the budget that was originally assigned to the IRS was earmarked for enforcement. So while they've already done a significant amount of hiring, any clawback in that is likely to reduce some of the audit rate. While it's not high from a historical standpoint, the intention was to use those additional funds to close the budget gap. And I know there was concern amongst certainly a number of our clients who I've spoken to, but taxpayers kind of across the US, that there would be a significantly more aggressive enforcement posture from the IRS. If additional funding is clawed back in the coming years, the ability of the IRS to really go after particularly the most complex returns, so high net worth taxpayers, complex business holdings, complex partnerships, is likely to coincidentally decrease. We'll also have a new Senate chairperson. Currently, Ron Wyden sits as the chair of the Senate Finance Committee. He's been a long outspoken advocate for aggressive tax enforcement and has had a couple of pet projects that have really been on his spotlight. So tools like private placement life insurance have been something that over the last 6 to 12 months, he's taken a personal interest in. Having a new Republican sit in that seat will likely mean the end, at least from a formal standpoint of a lot of those initiatives. As a member of Congress, he has the right to continue to request documents, but he won't have the ability to really drive investigations and inquiries in the way that we've seen when he did hold the chairman's gavel. At the IRS, you can expect to see a reduction in the amount of focus that is placed on ultra high net worth taxpayers, and really the magic $400,000 threshold that was a hallmark of tax policy under the Biden administration. So what does that mean practically? A long-held myth at amongst the American taxpayers about the IRS is that they're allowed to look at your income and specifically say we're going to pull a return on the basis of that income. What they can do, however, is say that We are going to screen out people on income, so anyone below a certain level will not be examined. And we are only going to look at certain strategies or certain types of structures as part of our enforcement strategy. Over the last several years, as part of the Biden 400K initiative, what they really focused on was how to even out the numbers between ultra high net worth taxpayers who were subjected to formal IRS audits, and to balance that out against the number of taxpayers below a $400,000 threshold. Individuals below that threshold tended to get pulled at a higher rate because of the use of computer algorithms, and things like the earned income tax credit, which are often misunderstood and misreported. And so the consequence of saying that those two buckets had to be relatively equal was that there had to be a much more aggressive position taken on audits for high income taxpayers. One of the statements that Congress has made, certainly the House over the last 2 years, and the Trump administration, was that their intention is to shift focus away from that type of bright lining, and to pull back some of the IRS's enforcement posture. So while audits are always individual, it really comes down to what's being reported on your personal return from a risk and a compliance standpoint. And then also just frankly winning the audit lottery. The odds may or may not be in your favor. Certainly the tables will tilt away from some of the audit selection that we've been seeing over the last 2 to 4 years under the prior administration. With that noted, though, an important takeaway is that the IRS is still an enforcement agency that continues under any and all administrations. So while there may be some policy changes in terms of staffing, and in terms of what topics are of most priority from a political perspective for the IRS, they are still going to aggressively audit things that they view as tax avoidance schemes. Things that are on what's called the IRS Dirty Dozen list are going to continue to be problematic structures and are things to be avoided or at least discussed with your tax professional. As we think about things like state film tax credits, monetized installment loans, conservation easements, terms that you may have heard in the past from various tax professionals or just around the water cooler at the cocktail hour. Those strategies that were problems under the prior administration are going to continue to be aggressively audited under the current administration. While the IRS and taxes tend to be a center point for politics, it is important to recognize that the IRS is not considered to be a political agency. What that means in practice is that there are only 2 individuals who work at the IRS who are political appointees: the commissioner of the IRS and the general counsel of the IRS. Individual campaigns, initiatives, individual audits do not change with the winds of new elections, new Congresses. And so from a technical standpoint, if there are things that are currently under audit with the IRS, or if there are structures and strategies that in the past you've heard flagged as being problematic, or particularly aggressive or risky, you should continue to assume that that still holds true. If there's something that you want to explore, certainly speak with your tax and legal advisor. Cresset doesn't provide tax and legal advice, but you can always meet with a member of the wealth strategy team, and we're happy to talk through pros and cons and how something may fit into your structure. But in terms of that landscape, we really haven't seen any meaningful change and don't anticipate seeing a meaningful change in the near future. We've talked a little bit about the courts earlier, but it is worth a quick mention. Courts drive tax policy just as much as Congress, in that they have the ability to throw them out and also shape how they are ultimately created. And this isn't a new trend that started with this election. We've really seen it over the last, call it 8 to 10 years, where the federal courts, particularly as the Supreme Court has gotten more conservative, has taken a much more strict stance around tax policy that is kind of pushed out by Congress and then written by the IRS without a lot of feedback from taxpayers and without a lot of time for people to contribute in around concerns and other things. A couple of major decisions, the Chevron decision that took place a few years ago, different Administrative Procedure Act decisions, all of those have really tightened the reins around how the IRS and Congress more holistically have to go about shaping tax policy. What that means practically is tax policy is going to move a lot slower, certainly the implementation of it. And instances where things were done hastily, we are starting to see those overturned. So just from a policy landscape, it's important to recognize that this is always fluid. The IRS has adjusted its policies to try to be more accommodative of things like the Administrative Procedure Act. But don't be surprised in the next couple of years to see additional challenges from Congress, from other conservative think tanks against US tax decisions that they view as unfavorable. And also don't be surprised to see more and more states fail in trying to challenge congressional authority as they run into increasingly conservative courts. And the final just major item, before I hand over the baton to Michelle to really talk about what I think is going to be the meat of the Tax Cut and Jobs Act for today's discussion, is around the probability of the extension of the TCJA, or the Tax Cut and Jobs Act of 2017. None of us have a crystal ball. We can't say what exact date they'll extend it or even under what terms. The important takeaways before we start seeing new bills are just that nothing's really changed from a planning standpoint. And I think you'll see that as we talk about the estate and gift tax exemptions. The expectation has been that there was a high probability that there at least may be a partial sunset of the TCJA in 2026, just because Congress isn't great at getting its act together and actually affirmatively doing things. But that we'd likely see some extension of some of those provisions. The probability is now flipped, that we will likely see an extension of at least some of the TCJA. It's more likely than not that it won't roll back. However, what that looks like is still very much up in the air. The expectation that there's just going to be a rubber stamp to extend TCJA in its present form for another 10 years really isn't realistic. The environment looks different. The cost of debt to the US is significantly higher, which impacts the scoring of different tax cuts. So a tax cut that might have cost $2 million before interest rates rose is now $6 or $8 trillion. We've seen individual tax exemptions come under heightened pressure as we have more Republicans in states that require a SALT deduction. So that'll be a horse bargaining chip. And even business tax provisions have been something that have been increasingly spotlighted as we think about bonus depreciation and accelerated expensing for businesses. So expect over the next 6 to 12 months, we're going to see a lot more detail around what those look like. As those different drafts come out, as those provisions are up, we'll have follow-on conversations like this to dive into them more deeply. But for today, for the individual tax cut side, we're going to keep it pretty high level, and then turn now over to Michelle, who can walk through what some of the implications are for the estate tax regime.
Thanks for joining us today, everyone. My goal in this part of the discussion is to really talk about what changed with the election and how should we think about our planning going forward. And, up front, the answer is not a whole lot. We're probably going to see a lot more of the same types of planning strategies that we've been talking about for a long time now. So get ready to hear a lot of, hold the course, more of the same type of planning as we wait to see what Congress, might end up doing. But, I look at this as there being 3 possible outcomes as a result of the election. Number one, it sunsets. If Congress, if the Republicans aren't able to act in lockstep in the House, and they have a potentially a razor-thin majority, and we know that there are 2 Republican Congress persons who were just tapped for roles inside the Trump administration, which would potentially cut their margin even further. We don't know if they'll all act together. If they don't act together, then the default is the sunset. We probably anticipate that the second option is what's going to happen, as Richard mentioned, that there's going to be some extension. We just don't know that it will be extended in its current form. And so we're anticipating that all of the planning that we've been doing is still going to matter, and that we're still going to have an estate tax exemption that we have to plan around. And then the third option is that, potentially the estate tax would be eliminated. It's not super popular. I mean, I know Republicans like the idea generally, whereas Democrats don't, of eliminating the estate tax. It's not a huge revenue earner. Um, Generally speaking, we get more of our tax revenue from income tax and very little from the estate tax. That being said, the Congressional Research Service estimated that if we extend under option 2, extend the elevated estate tax exemption, then it would cost $126 billion over the next 10 years. And it's possible that that price tag might be off-putting when you consider that the estate tax, historically speaking, does not affect that many people. Of course, with our clients, it affects many of them. And so we are certainly, trying to listen to what's coming and plan accordingly. To set the framework, TCJA was passed in 2017 in the middle of December, and it was effective January 1, 2018. It took the Trump administration about 2 years to get tax policy passed at that time. So when we think about next year, when we think about 2025, when the Republicans take over, we don't know if they're going to be able to pass anything before year end. And it will depend on what happens with the House races, and there's going to be potentially special elections for the individuals that end up leaving the House and go into the administration. And so there is going to be some time. And so we're advising clients, until we know more, assume that we have to plan around this estate tax exemption. And so all the planning that we've previously been discussing should probably still make sense for the majority of our clients. Why would we consider, why keep the planning in place? Well, the planning still provides asset protection to the extent that we put assets into irrevocable trusts. We are getting it out of our estate, and we are protecting it from our creditors, our beneficiaries' creditors, from the estate tax system, from the GST tax. And so all of those reasons still make sense. Additionally, after we've moved assets out of our estate, all the appreciation on those assets are similarly outside of the transfer tax system. So long as we have an estate tax system, we're going to want to keep moving the assets outside of that system into an irrevocable trust that can be protected from creditors and from taxes and from, future ex-spouses. And so all of those reasons still make sense. As far as planning goes, if clients were considering planning before year end, that can sometimes still make sense depending on how far in the process you are. Oftentimes it's difficult to get an attorney to do anything in November for year-end planning with all of the holidays coming up. But I would suggest that we still have a good 6 to 9 months to get all of this planning that you are potentially undertaking in place. I would say that the rush to do it before year end is probably no longer a rush. That being said, the earlier you do the planning, oftentimes the better the planning works, because you can get your gift tax return filed earlier, which starts the statute of limitations earlier. And as Richard said, we're looking at the next 2 to 4 years of, how control will be managed and how the courts will be managed and how the IRS will be managed. And, we have a 3-year statute of limitations for review and audit of a gift tax return. So the earlier that we can get it filed, the earlier it can hopefully get past, that period of time, so that we know that the planning worked. We also have 15 states plus the District of Columbia that still have a state estate tax. We also have 6 states that have an inheritance tax. Maryland happens to have both a state estate tax and an inheritance tax, which is where I spent a lot of my time practicing law when I was in private practice. And so again, for those people who live in those states, planning still makes sense, because every single dollar that you get outside of your estate, you're saving typically 10 to 16% of state estate tax. And so oftentimes these state estate tax exemptions are lower than the federal exemption. The federal exemption, by the way, is $13.61 million currently. Next year, we know that with the inflation adjustment, it goes up to $13.99 million a person. So it's effectively going to be $14 million next year. If you're married, you can double that. So it's $28 million that you can get outside of the estate gift and GST tax system. And so to the extent that we can move assets, we're not just getting the appreciation out, we're also getting it out so that state estate tax won't apply. And so, of course, all of the planning that we've previously discussed with all of our clients still makes sense. And we just want to make sure that if there are unknowns coming, that we can't anticipate, we always want to make sure that the planning we put in place is super flexible so that it can be unwound if need be. But given that we have state estate tax in many states, I think that we probably would not consider unwinding it in those states. But to the extent that clients live in a state with no estate tax, of course, we want to make sure that it's flexible and we can get the assets out if we ever need to. But ultimately, we typically like it in trust so that we can keep it protected from creditors and predators. Okay, so what still makes sense? Typically, we always want to make sure that your lifetime capital needs are met before you plan with any of your wealth surplus. So we never want clients to overplan and then live off of these irrevocable trusts because that planning has failed. In that we want to make sure that we right size a transaction so that you have enough to live your best life. And then to the extent that there's excess funds, that's the money that we plan with for irrevocable trust planning, for philanthropy, for all the things that we want to be able to do that's not going to affect, our day-to-day capital needs. And so to do that, we oftentimes suggest that clients, make gifts and use up their lifetime exemption into irrevocable trusts. If you're married, that oftentimes looks like a spousal lifetime access trust, a SLAT. So that planning absolutely still works. If you're not married and you have either kids or other beneficiaries you want to benefit, you would just gift or transfer or sell potentially into an irrevocable trust for those individuals. But you have to be careful because we want to make sure that you are fine parting with those assets and not having the ability to use them for your own personal needs. That's why we only plan with our wealth surplus and not with our lifetime capital needs. The same planning still makes sense as well, where we do a sale to an irrevocable trust. Oftentimes it's called an intentionally defective grantor trust, an IDGIT, and that's because it is intentionally out of your estate for estate tax purposes, but still your legal responsibility for income tax purposes. So we still want to make sure that we can do sales to those types of trusts, because again, that gets the appreciation on those assets out of the estate tax system, and where it can compound without the tax drag, because you're responsible for paying the income taxes on these irrevocable grantor trusts that you create. Additionally, we have the GST tax to contend with. The GST tax is the tax that is imposed on transfers 2 generations or below. We have a 13.61 million exemption from the GST tax, but anything that goes to grandchildren or more remote descendants, or someone 37.5 or more years younger than you that's not a descendant, is potentially subject to this GST tax. And so we want, and I'm aware of no, planning that would eliminate that. So we still need to make sure that we get assets out of the estate, and oftentimes a sale can get you there, because the sale means that the asset would be exempt from the GST tax in the new structure because you paid, adequate consideration for the asset. Okay, so what changes can we anticipate going forward? Richard touched on this briefly, but PPLI is probably not going to be under investigation in the same way that it was under Ron Wyden. Grantor trusts were previously discussed by the Biden-Harris administration as potentially something that they would want to put strict limits on. And a lot of the planning that we do with our clients revolves around grantor trust planning, because you can essentially sell to a grantor trust without facing gains, because it's almost like you're selling it to yourself. And so we are less concerned at this point about issues with grantor trust rules being revised or having limitations on how long a grantor trust can remain a grant or trust, or when it has to have the tax be paid by the trust itself. As Richard also touched on, less funding for the IRS means probably less audits. And so for those who are doing planning that is, let's say, aggressive or close in time or, concerning, those concerns should still, those concerns aren't going away. But if there are less people that are being funded to enforce, then of course there's going to be less, boots on the ground that can attack those transactions. As far as I'm aware, the rates haven't been discussed to be changed. The estate tax rate is currently 40%. And so we're still planning as if that's not changing, but as if it changes, we will we'll have to talk, we'll figure out how to plan around any of the changes that Congress might suggest. I'm going to turn it over back to John Crow for final questions.
Great. Thank you, Michelle. Thank you, Richard. Lots of great information in there, and appreciate the update. So got a number of great questions that have come in. So we'll kick that off, and for the audience, to the extent you have further questions, if you've got one, please put one in the Q&A button at the bottom of the screen there, please. I'll let one of you kick this off, and then we'll go from there. First question is, will estate taxes go up? And if so, or even if not, should I use my lifetime exemptions without giving away too much, is the question.
I don't know that estate taxes will go up. I haven't heard that. I doubt that is what Republicans want to promote. I think the question might be whether they reduce the percentage, the rate, but I haven't heard anything either way.
Yeah, I would say there tends to be two levers that exist. One is the exemption level, and then the second is the actual tax rate that's applied. We've seen a lot more volatility historically in the exemption levels than we have in the specific tax rates. I haven't, to Michelle's point, seen a lot of conversation around changing that. Typically, if it's going to go up, that would be under predominantly a Democratic administration in Congress. Republicans historically are more opposed to the estate tax broadly. But there are a number of Democrats as well. So even during Build Back Better, we didn't really see a whole lot of rate change. That tends to come out of, I would say, more the far left economic agenda, the Bernie Sanders of the world, who talk more about 70, 80, 90% tax rates. But a 5 or 10% rate, just from a scoring perspective, isn't meaningful. And really, as we go into next year, that's going to be the name of the game, is how do they figure out what they can swap to try to make things as close to revenue neutral as possible. The closest recent estimates have the Tax Cut and Jobs Act, just in its current form, if it was extended, being north of $7.5 trillion in cost. So paying for some of that is probably going to mean some gives somewhere. That's why we're not expecting the estate tax to just go away, even if they wanted it to. They need a couple of extra chips. And you may see things like the corporate tax rate and others being more prime to go up than something like the estate tax rate.
No, that's great. And maybe just I'll tag the last part of that question. It's just maybe some broad thoughts. And I think you both get this question a lot, I'm sure, from clients where, to the exemption amount and how it's been in flux. And what are some of the things that you think about or talk about with clients as far as what's the appropriate usage of that exemption, and how does that look within the current law, and maybe just provide a little context around that.
Well, we never want them planning with money that they absolutely need to live. Clients will oftentimes get into over planning where they gift more because they want to make sure they use up every single dollar, in that exemption. And that doesn't always make sense either. And of course, it's a function of how much they have, how much can they plan with, since we can't plan with certain assets like their primary residence or retirement assets. But this comes up a lot with clients who have, I would say, maybe 40 million or less. It's really hard for a married couple with 40 million to give away $28 million. Looking at what they need to live off of, plus what they have to keep in their name, like their home, which isn't going to produce income. So over planning is a problem. We like to try to size the transaction to make sense to for tax efficiency purposes, optimizing how much exemption they can use while we have it. But sometimes it might make more sense for clients like that to hold off, see what's going to happen with the exemption and then act, or get appraisals now for the assets that they might consider gifting and then hold off and see what Congress is going to do. So they're ready to jump when need be.
That's great advice.
Yeah, I would echo a lot of that. I would say flexibility is the key. It's not going to be the sexiest answer, but really, there's been telegraphing around potential changes in the estate tax rate. I'm sure everybody on this call is probably sick of hearing about it for at least the last several years. So if in talking with your advisor, what's made sense for the last 2 or 3 years is for you to do some gifting, it still makes sense, even if we expect there to be an extension of the exemption rates, because you're still getting dollars out of your estate, you're still facilitating all of the wealth transfer and legacy objectives that are really the underpinning of your planning. Tax, I say it a lot, is really just a impediment to getting to your goals. It's not a goal in and of itself. And so while we have less tax friction on you accomplishing our goals if they extend the TCJA, that really should never have been the driver to start with. And so we tend to look at things like slats, which give us the ability to be a little bit more aggressive based on our modeling in terms of how much money we can afford to transfer today while expecting to have the ability to take it back if we really needed to down the road. It should never be the expectation. We can look at things like optimizing using one spouse's exemption. So part of the original clawback analysis was if exemptions dropped from, say, 14 to 7, how do you make sure to lock in at least some of that exemption? And one way to do that is to use just the first spouse's exemption, use all 14, because then if the exemption claws back, one spouse will have lost 7 million in exemption, but the other will have locked it in. And then the last is really just not getting caught in the trap of thinking it's an all or nothing. A higher exemption means you can afford to give away up to 14, but maybe 8, 9, 10 is what makes sense for you. And that is still a win. It's easier to look at what you left on the table, but we shouldn't lose sight of how effective some of that planning can be on the front end.
No, that's great. Thank you both. The next question that came in, this is interesting in a post-election period that came through is what type of tax benefits, if any, can I have moving to live abroad?
So I think this one comes up a lot on both sides whenever there is a election. I often call it the Tina Turner approach, which was relocate to Switzerland. The reality is moving internationally is far more complicated than most people, I think, imagine in their minds, not just from a tax standpoint, but from a livelihood standpoint. Oftentimes, especially Cresset's clientele, where a lot of you are still in your working years, you're still founding companies, you're still having contacts here. Moving abroad can get in the way of you being able to facilitate the business that generates your wealth and cost you more than what you may ultimately save just through good, effective tax planning. It's also really hard to separate you from your nexus or your attachment points to the US. If you're coming back here to do business all the time, so you may not see the same tax benefits that you're kind of imagining. From a tax standpoint, often the other side isn't as green as expected. There are exit taxes as a US citizen if you were to depart. There can be some onerous tax regimes depending on what nation you choose, and it is going to have to be one that still meets your social and personal needs as well as your economic needs in terms of being a favorable business environment. And having infrastructure and travel. So it's certainly something, if this is going to be a refrain you hear a lot from us on this today and in any calls you have with our team. But if your goals are saying that you want to be in another country, then what we can turn to is how do we make that tax efficient? But if the sole reason you're wanting to uproot and go abroad is to save on taxes, historically, the math just isn't going to work out. And I can say personally, for me, having done that analysis for a lot of clients, very rarely is it favorable. Michelle, any thoughts from you on that?
I would just say that, unless you're expatriating, and like you mentioned, there's an exit tax on amounts over 2 million. But if you're not expatriating, well, the US still taxes on worldwide income. So to the extent that you earn income elsewhere, we're still going to tax you on it in the US. And so you really haven't, changed your tax position unless maybe you are no longer subject to state income tax. But that's domicile planning, and we certainly do a lot of domicile planning, oftentimes within the United States with a lot of clients.
Yeah. John, if I can interject that
Yeah.
actually did one additional one. Puerto Rico comes up a lot. There are potential benefits to the Puerto Rican tax regime. That's again one that's a lot more complicated than it may appear on its surface. So certainly if that's of interest, speak with your wealth advisor. We can talk through what that may look like for you from a practical standpoint. But what I wanted to particularly note on that is going back to what I said earlier about, the IRS is still the IRS. The Department of Justice is still the Department of Justice. Puerto Rico, for instance, and some of the other international tax shelters are still very much in the spotlight of enforcement agencies. That hasn't changed with the Trump administration. So ongoing federal investigations, they still have 50 agents that are residing in Puerto Rico. So it's just a reminder to us all that while things have changed, it doesn't mean everything is going to change. So still give some real thought to whether it makes sense for you. And if it didn't in the past, maybe it's worth another conversation. But the likelihood is if it was a hard no before, it probably hasn't swung to be a yes now.
Right. No, good advice, Richard, on that front. Next question was, what should I do if I have a large capital gain from the sale of a business in 2024 or 2025? I think they're asking a timing question. So part of that is, maybe some strategies around reducing tax on a sale, also the timing element of it too, possibly if they could defer or not.
Well, if you're selling in 2024, you have limited time to get that done, in which case you have limited time to get any additional planning done, pre or post sale, to happen in 2024. For 2025, we certainly have a longer runway. I think the most common suggestions include tax loss harvesting and charitable planning. So charitable trusts are oftentimes, or contributions to donor advised funds or foundations are oftentimes suggested in a year of a transaction. Richard, do you want to add anything?
Yeah, I think a lot of the pre-liquidity planning that we would generally think of still holds. To Michelle's point, charitable planning is still going to make sense. Installment sales can still be a great way to incorporate some tax deferral in. Use of certain trust structures, depending on what state you're in, can be meaningful. Again, kind of on the flip side of what I just said with Puerto Rico, those things are pretty well established. They're not going to suddenly change either, just because we have a new administration. Prior planning is still good planning. I think the timing question, though, does open the door a little bit to, I think, something that comes up a lot as we're thinking about what tax looks like next year, because just like before the election, 2025 still looks like a bit of an unknown. While we expect that they'll continue to work on the TCJA and other acts next year, whether they're able to kind of strike while the iron's hot and get something done in the first 3 or 4 months, or if they do what the US Congress often does and wait till the last minute and extend it into next year, we know what the tax policy currently is supposed to look like for 2025. It's really just a continuation of what it looks like this year. So while there is some timing risk of, there's virtually no chance they're going to change anything before the end of this year, you can probably pretty effectively lock in your tax outcome this year. I wouldn't put the risk next year at particularly high that you're going to see some huge change in the tax system either. More likely, if they extend it, it'll start when the TCJA was already set to end, which would be January 1st of 2026 onward. Where you may have a trade-off is if they do some incremental tax cut and it's a little bit earlier, then it may be that 2025 was a year where capital gains went down 2% relative to what you paid this year. And then to John's earlier point, there's always a tax deferral element. If you can kick it into the next tax year and get an extra 12 or 18 months, as a tax person, that's generally going to be a win.
Good, great. Well, we've got time for a couple more. So I think this one is a good one. They all are, but the question is, we are still relatively young, 49 and 50, and have 3 school-age kids. Does it still make sense to put assets into irrevocable trusts at this point? Or is asset protection more important than estate planning at this point? Both of us are still working and plan to work for another 15 years or so.
I think it's hard to answer that question in a vacuum because I don't know anything about the size of their estate and what their lifetime capital needs are to know what they need to live their best life and then how much can they then plan with. Typically, if there's an excess, that they can plan with and you have a spouse and you have kids, then oftentimes it still makes sense to do the planning now because you can get a substantial amount of money, even if you plan with less than your exemption, right? Even if you do a smaller gift of, $1 to $3 million into a trust, you can still get the appreciation on that over time out of your estate. And, a lot of younger clients have the benefit of time where they can do a lot of this planning without needing to maximize the exemption to the exact amount that they can, leave and get the largest discount. I mean, they have the benefit of time that allows them to transfer over, many more years, the time value of money, right? So as it compounds and as it grows, planning can still make sense, even in smaller increments, even for younger families. I think the question might be a little bit different if the answer is I'm not married and I don't have kids, because then it's, well, who are you planning for? And are you okay not having access to that money?
And it maybe can extend because it relates to another question, actually, is that second part of that question, a little commentary on from the two of you around the, which sometimes I think gets lost in the planning. We get focused on tax a lot. Maybe some of the thoughts and commentary around asset protection and how do we layer that into some of that planning.
Sure. So I can take that one. I mean, I think it kind of starts with the term estate planning. There's a reason we say that rather than just tax planning. Estate planning is far broader. It's far more holistic. And so while we try to optimize your tax planning and your estate planning, and in some cases, tax may be a large motivator for why you're willing to pay, a significant amount on the front end to an attorney to get some of these structures in place. There are a lot of associated benefits that are meaningful in their own right. The peace of mind that comes with knowing that ultimately your family, the people and causes you care about are going to be provided for is a direct benefit of estate planning. Not having to have that rough transition period if you were to pass or to be incapacitated, and making sure that your spouse will continue to have access, your kids will be provided for, their education will be funded. From an asset protection standpoint, it can be meaningful, particularly if you have multiple homes, or for a lot of you as business owners, being able to segregate out some of your assets and put them into structures that can help insulate you as you become a larger target, to be blunt, in an increasingly litigious society, is really meaningful. And so the best estate planning and what we really strive for, and it goes to Michelle's earlier point about wanting to understand you as a family, you as in terms of your goals, your balance sheet, is that all of those inputs ultimately drive it. And ideally, we're checking a lot of different boxes. Really, the question we should always ask ourselves whenever we do any tax planning is, if the tax outcome we wanted didn't happen, would we still be okay with engaging in the planning? And the best estate planning, the answer should still be yes. While the returns or the gains may be diminished, they should still be there. You should still have peace of mind. You should still have additional asset protection. You should still have a sense of legacy. And you should still have the flexibility, that Michelle talked about of, we don't have a crystal ball for the next 100 years of what your heirs and beneficiaries are going to look like. We also don't have a crystal ball around what the tax landscape is going to look like. And so it could be in the next year, or it could be in 50 years, the estate tax system goes away. It doesn't mean the planning wasn't good. It was the best we could do with what we knew at the time. And making sure that we balance that sense of wanting to be proactive and efficient with being flexible and conservative is really why we try to take that planning-driven approach here of saying, what is your lifetime capital needs? What is your wealth surplus? And what is that constellation of other goals that we can wrap that surplus in?
That's great. All right, one last one, just kind of in and around Roth conversions. Are they a strategy for reducing the size of your estate and future tax burdens?
I mean, I would always suggest talking with your wealth advisor and modeling what a Roth conversion looks like. But to the extent that you pay the tax up front, okay, if you are in a federally taxable estate, or even a state that has estate tax where you would be subject to state estate tax, but not necessarily federal, or both. Yeah, a Roth conversion, ultimately, it's part of your assets to the extent that you pay the tax now, you're, prepaying the tax, so you're lowering the size of your estate. So then when you pass away, you don't have to pay estate tax on the value. And so that can reduce the amount of tax you end up paying if you've, prepaid up front. The hard part is convincing a client to pay it now, because why pay now if if I can pay later? But yes, it can reduce the tax due, the estate tax due.
Yeah, and I think, to Michelle's point, speaking with your wealth advisor, these calls can never be fully comprehensive. There's always going to be unknowns based on your particular situation, based on kind of what crossed the newswire. And really, your wealth advisor is the gateway not only to information on this, but to our team as well. And that's really what we're here for. It's to help you outside of these calls really dive deep into what your particular goals are and what's in the toolbox that could benefit you. Because if there's any known, it's that tax policy is always going to change, but there is always going to be some opportunities out there, whether that's qualified opportunity zones and whether they pop back up, whether that's Roth IRAs and their creation in the 90s, whether that's using something like PPLI and incorporating it into your estate plan. There are great strategies, some really simple and low-hanging fruit like Roths, some more sophisticated like PPLI, but we probably have some sort of solution out there for you. And so that really just starts with engaging with not only our team, but your advisor. They're here to help. And with all the uncertainty in this next year, all the things that will pop up, utilize us and our resources to help give you some surety and also to get some more optimized outcomes.
No, that's great. Well, thank you both. Such great information today, Richard and Michelle. Really appreciate that. And to your point, and to the audience, again, reinforcing that, talk to your advisor, check in with your advisor. They'll be checking in with you, especially as we keep going to the end of the year. So appreciate that and appreciate that great information, and encourage everyone to take that proactive approach to your tax and estate planning. Now is the time to review your strategies and continue consulting with your various advisory team on any adjustments that can help to protect and enhance your assets as we approach year end and after year end as we go forward together. So thank you all, and we look forward to connecting again soon. Thank you very much.